May it please the court, I'm Christian Pearson and I represent the state of Washington. I would like to reserve 2 minutes for rebuttal.
Reserved.
I'm here today to ask that the court grant the state's motion in limine. The state requests that Ms. Walker's high school transcript and the victim, Mr. Russell's testimony about his conclusions based upon that transcript be admitted as evidence. The evidence should be admitted for 3 primary reasons. First, the evidence is being admitted to prove a required element of the offense, that the victim was intimidated. Second, the evidence is relevant in that it establishes a material fact, the intimidation. Third, the probative value of this evidence for proving a necessary element outweighs any potential to cause unfair prejudice against the defendant. First, for the purposes of RCW 28A 635.1, the state must show that the victim was actually intimidated. Whether or not the victim was intimidated is determined by a reasonable person standard. The victim's fear must be reasonable in light of the circumstances in the mind of a rational person. This comes from State v. Avila, a case with actually similar facts to the current case. The student in that case threatened to blow the teacher's head off, whereas in the Walker case, she threatened to blow him away.
Well, but counsel, in terms of the reasonableness, that's the reasonableness of in this case, the teacher.
Mm-hmm.
So how is his fear reasonable?
Well, that goes to the relevance of the evidence. The evidence is relevant if it makes the fact more or less probable. And in State v. Reagan, a case in which a defendant and a victim were acquaintances, the defendant told his acquaintance about his criminal history, including bomb-making abilities, access to guns, ties to organized crime, criminal history, and the fact that he suffered from episodic rages.
But counsel, isn't that a little over the top when we're talking about a student who doesn't have a criminal history? How are these cases, how is that case parallel?
The case is parallel in that the court held that the jury was entitled to know everything that the defendant knew, or everything that the victim knew at that time about that defendant, to see if the emotion he was feeling at the time, the fear, the intimidation, was reasonable. In this case, the transcript provided Mr. Russell with context, provided him with fleshed out the situation for him that he was in.
So the rule from that case is that generally a complainant or a victim is entitled to know everything to support, or is entitled to tell the jury or the court everything that supports their fear, whether it's severe criminal activity or
absolutely
school
right.
activities.
The rule in itself does not specify that it has to be a criminal activity. And in a similar case, State v. Johnson, the defendant was his prior acts of simply being controlling and domineering and over listening to his wife's conversations, asking her about infidelities, things of this nature. Those were included as evidence in a domestic violence charge against him.
Did that defendant have a criminal history?
That defendant had a domestic violence conviction. However, the court stated that it was about the fear itself, it wasn't about what actually happened, it was about the state of mind that was created in the victim at the time.
So your argument is that this evidence is relevant to prove a state of mind, and it doesn't matter whether the defendant here had any prior criminal history?
Yes.
Okay, go on to your next point.
So, yes, Mr. Russell, having read Ms. Walker's transcript, was troubled by what he read, and the transcript and his own conclusions are to demonstrate to the court his state of intimidation. The third point I would like to make is the probative value of the evidence for proving a required element outweighs any unfair prejudice. Going back to the State v. Johnson, the domestic violence case, the court said, obviously the evidence was prejudicial, but that is not the test. The test must be whether it is unfairly prejudicial. And a further illustration of that, in the state v. Lowe, a man was charged with rape. The modus operandi for his offense was drugging women and then raping them. This happened on 4 previous instances. So 4 uncharged previous instances. The woman came forth to testify in the case at hand, and the court allowed the admission of evidence of rape as...
Even though he had no prior charges of rape.
No prior charges of rape. This was just, that was to prove plan or scheme. And the court allowed it, and even though it was extremely prejudicial information. I mean, they called him a rapist. But the court did allow it because it was relevant to prove something else. It was relevant to prove something that was necessary to the state's case.
How do you respond to the state's potential argument that the admission of this evidence is to prove her character?
The defendant's character, that would be a question of, would not be a question of how he felt. That would be a question, we're not asking the court to look at who she is, we're just asking to look at how she acted at that time and why that action affected the victim in the way it did.
And the prior instances which he did not observe or know about until he did some research.
Correct. Yeah.
And also the record seems to indicate that at the time he did that research, he was merely looking at that to see if she was okay. And then now it's converted into, oh, now I'm afraid of her. How do you explain that?
Well, when he did the research, he did it before the incident in which she said she would blow him away. He did that after a previous event in which she had caused a disruption in his class, and then he went to do that research to see if she was okay. Having that research in hand and in mind, then when the actual event happened, he was intimidated because of what he had researched from the events previously.
So the courts would convert like prior known bad acts from not necessarily being bad to, oh no, this is bad now?
Correct. Because it might not be entirely obvious to a judge or jury why a grown man would be intimidated by a 14-year-old girl, it is necessary for the finder of fact to have all available facts that were available to the victim at the time. And for those reasons, we ask the court to grant the state's motion.
Thank you.